Welcome back to the program. Let's begin our conversations by introducing our guests for this segment. Yabagi Yusuf Sani is National Chairman, Interparty Advisory Council, IPAC, and he joins us live in the studio. Thank you very much. Good to see you once again.
Good morning. Thank you for having me.
Jide Ojo is a public affairs analyst, and we know him. He's a friend of the house. Mr. Ojo, thank you very much once again for joining for this conversation.
My pleasure. Greatest Akokite.
And Dr. Sam Oguche, Consultant Coordinator, IAGA Africa Center for Legislative Engagement, is also here with us. Thank you, Doctor, for joining us.
All right. So, gentlemen, it's our pleasure to have you join us. And, of course, we are taking on this subject matter because some of the tribunals have delivered their judgments. There are some 400 or so outstanding cases out of about 552. So which means 152 have either been decided or some of the petitions withdrawn. But we won't get into specifics of those matters that are still pending before decisions are delivered. That's one of the boundaries that, of course, we'll have in the course of this conversation. But in general, let's start off, gentlemen. More and more electoral outcomes have shifted to the judiciary for determination rather than it being, as it were, the voters on the day of voting determining who gets elected. How concerning is this? Let's begin with Sam Oguche.
Okay, thank you very much. If you look at the nature of Nigerian elections, judicialization of the electoral process is now the order of the day. And you can attribute it to the level of faith the electorate have in the umpire and the entire process. When people don't accept electoral outcomes, it's a sign of their disapproval of the process. Looking at what we have in Nigeria today, the polling units no longer determine the outcome of elections, except where the losers, in quote, choose not to go to court. But if you study recent trends, especially in the Fourth Republic, there's hardly any election that is not contested after the conduct, that is by the judicial process. Now it has become so because of the nature of the conduct, the process, pre-election, election, and post-election period. So people now find out that, look, there's a lot of manipulation in the process. Some feel that, oh, they have been cheated. Some feel that the law has not been complied with. Some feel that they are actually, they actually won, but not the court. So looking at the trends, it has become, many people have gotten justice from the court system, the tribunal system. So it's a kind of hope for people who feel cheated that, look, actually, we cannot resign to fate, but we can approach the tribunal to reclaim our mandate. And that's why recently you have been seeing a floodgate of nullification of elections. So it tells you that the conduct is flawed. And that's why even pre-election and election period, even down to post-election era, many reports were released. Even political parties issued statements as to the nature of election conduct. In fact, before the election, there was a report, Election Manipulation Risk Index, which should use various variables and indicators to indicate which states are high-risk states, which ones are medium risk, which ones are low risk. And if you look at the trend of the outcome of the judgment, it goes to validate those findings. So people have, it's a kind of disapproval. That's not to say that there are no frivolous petitions. They are. But if you combine them, the conclusion will be that, look, let us go. The judiciary is there as a last hope to determine.
All right, Dr. Guche, thank you. Thank you for your opening remarks. Let me also bring in Alhaji Sani into this conversation, who is the, of course, National Chairman, Inter-Party Advisory Council, IPAC. Dr. Guche just talked about, judicialization of, the process. And some people would say that the parties, not even the candidates, the parties enable this judicialization of the process. And by not being able to study adequately and understand the various documents, that, regulate the process, how, candidates are nominated, how parties are conducted, and so on and so forth.
Yeah, well, we must understand one thing. Where are we coming from in the issue of electoral process, conduct, declaration of results, and things like that? We are supposed to have left the heavily manual system of conducting our elections. That is what Electoral Act 2022 was aimed at achieving. Meaning that we were told that the system has been digitalized, automated, so to speak. But it was discovered that it became more manual than even what we had in the past. The system, the process. The conduct of the 2023 election was even more manual than what we had before, which means we have not moved the needle yet, as far as digitalizing, automating, improving on the electoral process. That's why you have...
On the part of whom now? Is it
on the part of
the electoral body or on the part of parties?
On the part of the National Assembly, all the institutions that are involved in the process, National Assembly, INEC, political parties, Nigerians themselves, and the pressure groups. I'm talking about now the CSOs and what have you. Because we saw the document, we saw the process. The most critical aspect of election, the most critical, and that's why there's a saying that it's not those who cast the vote that determine who wins, but those who count the votes. Those who count the votes, they're the ones that determine who wins. That has been the practice all along. So what did we do to that critical aspect of the value chain in the process of conducting elections? We did nothing. Nothing was done as far as counting, collation of the results is concerned. It was left as manual as it used to be. So that is the...
Let's even take the political parties, for instance.
Yes.
As a starter, you have talked about all the various institutions that are involved in the electoral process.
Yes.
So let us even begin with the political parties.
Yes.
How is it that political parties really understand even their own structure?
Yes.
Yes.
No.
Because if you look at the various verdicts that are coming in, some of them were thrown out because of invalid party structure.
Political parties are victims, just like Nigerians themselves. We are victims because look at the process from the beginning of the uploading of the people that wanted to contest elections. We had to go to court on so many issues. We are in court, INEC was in court, we'll go to appeal court, INEC will go to appeal court, you go to Supreme Court, INEC goes to... It shouldn't happen in a case where you have a clearly written law that is understandable by everybody. So the issue now is in the process. And if we love this country, because elections matter, really, whether any system of government, especially in the democratic system of government, elections matter. So we must revisit the Electoral Act 2022 and those obscured, those minefields that were put in that law should be removed. The Supreme Court should revisit.
Okay, let me bring Jide Ojo.
I know Jide is coming in, but while we are still on this, Jide, I want to pause you. I'm wondering, do you feel let down as IPAC? Because on Good Morning Nigeria, on a number of occasions, ahead of and in the course of making the Electoral Act 2022, political parties were insistent on their own contributions to the framing of that act. And you made a number of arguments as to why you needed to make your own contributions. And there was hope that, the Electoral Act 2022 would be a game changer in the conduct of our election, and therefore less recourse to the judiciary in determining electoral outcomes. How disappointed are you?
Oh, believe you me, we're at sea as to what is happening today. Because how did we get where we are is the question. With all the brilliant, lawyers we have, the people we have in the National Assembly, the judiciary themselves and things like that. How did we get here? That today we are at each other's throats. Everybody is fighting each other. Is it the INEC? Is it the political party? Is it Nigerians? Is it the judiciary? Everybody is brought into some kind of dispute, that shouldn't happen. If you had the law that is so clear and ambiguous, because the Electoral Act, if truth must be told, if you look at the sections that talks about what the job of the returning officer is, it's as manual as it used to be. Nothing has changed in that respect. Yes, Beavers did very well. It was a game changer as far as accreditation is concerned. Meaning that as far as not allowing politicians to now, manipulate the process, sending people there so many times to be counted as voters. That it worked. But that's where it stopped. Nothing again was added. Because the counting was as manual, was as in total control of the INEC as it used to be. And that's why all the cases you found now are against, is between the contestants and the INEC. So this is what happened, because if you are talking about rigging was not done by politicians anymore. It was done by INEC officials.
We don't have any proof of that. And
When I said if there was anything like rigging, it's about the counting, it's about the collation. That's people are fighting all over the place.
We'll say the miscounting.
Okay, the miscounting. Maybe the miscounting because of the environmental and the man and the human errors that are there. That's why I said even INEC is a victim. Believe you me, they were also there as shortchanged. The INEC officials themselves, as all of us.
Let's pause you. And Jide, you've heard him. If you look at the various verdicts that have come in so far, yes, Beavers was mentioned as a factor, but most were because of party structure. Now, parties are blaming the system. Our political parties and candidates themselves, can they be exonerated from all of this judicialization of the process?
Thank you very much, and good morning, Nigerians. For me, as a student of politics and somebody who has worked in this field for over 20 years, the blame can go round. And I'm not trying to trivialize the process. At the apex of the blame game are the politicians, because unless we are not willing to tell ourselves the truth, who are the makers of the law, the framers of the law? They are politicians from different political parties who came together and said, these are the reviews and reforms we want to see. So it starts from there. Then, who are the people who enabled INEC ad hoc officials to rig the polling unit or collated result? They are the politicians that will pay heavily money that these coppers have never seen in their lives. Imagine somebody being given 20 million, 3 of you go and share it, but give me this outcome. Who pays for it? The politicians. Now, I want to throw a challenge to my colleagues in civil society. organizations like CDD, like Young Africa, have to also invest some resources in research. I would like us to make sweeping statements about, oh, most of the results were nullified. It's like the Court of Appeal judgment of last week. Oh, elections were rigged in many states. Which polling unit, which ward, which local government before you come to the state? So what I'm saying is that we have had 7 elections, general elections. Can we have a research output? Maybe National Institute for Policy and Strategic Studies or National Institute for Legislative and Democratic Studies can also take this up so that I don't overburden civil society. If NILS or NIPS can take up that research, 1999, these are the number of cases filed at the tribunal. These are the outcome at the court of first instance. These are the final outcome. Let's have a well-informed debate about the level of nullification of results. Because, for instance, in Osun election, the court of first instance nullified the election of Ademola Adeleke, senator. But the subsequent courts upheld those elections. Now, it is important to keep that in view so that we don't take raft of decisions to judge whether the elections were laudable or were condemnable. So it's a challenge I'm throwing out. But coming back to the issue of whether politicians have a blame, again, we need a research. How many of pre-election matters arising from party primaries conducted by these political party chieftains were contested? How many post-election matters were contested? What is the ratio? Because whatever you see at the election is a manifestation of what happens during the party primaries and the pre-election period. Many cases are being thrown out now, or judgment is being delivered based on what happened in the pre-election period. Issues around nomination are still being canvassed. Oh, there was a flawed party primary, or the party substituted me wrongly, or stuff like that. And we know how heavily monetized the party primaries of some of the political parties were, particularly the dominant ones, where we were told dollars were exchanging and millions of naira were being given to delegates to compromise that process. So you cannot now push those candidates to INEC, and all attempts of INEC to also have technology-driven elections are thwarted. Because INEC tried to do biometric registration of voters, by uploading of candidates' nomination, uploading of accredited observers, uploading of so many things were digitized. But then you come to electoral 2022, which became ambivalent about the role of electronic transmission. There is, in one breath, says electronic transmission, in another breath, it said transfer. Is transfer and transmission the same thing? Who created that challenge? Is it not the National Assembly? Who are members of the National Assembly? Are they not the politicians? So we need to have a global view of what is happening to our electoral process that has been a cog in the wheel. When people are making laws that are self-serving, that are not in national interest, you cannot but get this kind of output. And I tell you for free, bring people from US to come and conduct this election. With the kind of legal framework that we have, they are going to face similar challenges. Because at the end of the day, you blame the judiciary. Say, oh, judiciary is throwing out these cases. They have, there is something I mean, my article is coming out tomorrow on the Presidential Election Petition Court. The court will not nullify an election based on certain infractions or whether there were infractions at all. The court will look at provision of Section 134 and Section 135 to talk about substantial non-compliance. So it's not about, oh, was the election flawless? No, the presumption of the law is that there could be flawed election. And that's why they say election will not be nullified except there is a proven case of substantial non-compliance in the opinion of the tribunal or the court. So what amounts to substantial non-compliance? Oh, election started late. Is that substantial non-compliance? Oh, some people were disenfranchised. What's the number? Was there massive? Oh, there was violence in 1,000 out of 200,000 polling units. Is that substantial non-compliance? It's not like there will not be issues. It's not like there will not be flaws. But what the court, what their lordship will look at is how massive, how widespread are these. And there are provisions. Okay,
and the substantiation of those.
Of those. And then you don't say, oh, the election was flawed. There was violence. Okay, were you there when that violence took place? Oh, I was told. My friend called me and said, oh, they have scattered the... Were you there? Did you witness?
You see.
Because this is not about elections. Thank God my Oga here is a lawyer. And he is also a lawyer. It's about eyewitness account. You cannot rely on third-party hearsay to come and validate something before their lordship.
It's never admissible.
Because when you are making criminal allegation, the presumption in law is that you must prove beyond reasonable doubt. So you have accredited polling agent, and the polling agent brought you result, and you say, oh, I can't take this to the court. Then I brought an expert who is not there, who worked on another document. I want to use that to come and plead my case at the tribunal. Their lordship are likely, and it's not something that just got newly invented.
Can we just pause you?
Yeah. Jide, thanks a lot. This is, I'm not a guest, so I want to ask the guest to. This is part of the challenge. What Jide has been trying to explain, let's just summarize it briefly. Sometimes the talk on the street isn't the same talk at a tribunal or in a court. The talk on the street. That's why the example he was giving you. Oh, I heard there was a lot of rigging, there was a lot of violence, X, Y, Z. Now you also have to come to court to prove that. And then you have to be, as you have said, you have to be a witness so that you heard X, Y, Z. But if a report was made to you as a police officer or a law enforcement officer, that might also suffice. But there are ways for handling that without getting into details. You also were talking about transfer and transmission. With the most tremendous respect, of course, everybody who listened to the judgment of the Presidential Election Petition Court had references being made by way of definition of transfer and transmission, whether it was electronic or otherwise, and then having recourse to Black's Law Dictionary. I was just chuckling to myself. Obuche, you will understand this. I was chuckling. I said, look, perhaps we could also have summoned the corporate governance terms, transmission and transfer of shares. There are two different things, but you're also transferring interest in shares. Well, transfer, of course, is done when you are alive, and that's your own action and transmission. So let's not get into that.
Taking us back to law school.
Oguche, I'm going to have a break. No, before we take the break, let me just mention this, that it is not in all the judgments that we have heard so far that the blame has been, for instance, on the non-transmission of the results or INEC not performing its role. For instance, one of the decisions related to the fact that a candidate in that election who was returned as elected did not resign his appointment while he was still a lecturer 30 days before the election.
Please hold.
All right, you're welcome back, and it's still Good Morning Nigeria on the network service of the Nigerian Television Authority. Let's bring in again Sam Oguche. I was saying just before we went on the short break that it's not in all the judgments that you have seen the blame slammed, for instance, on the conduct of the election itself. I've cited the example of a candidate who was returned, but of course it was deemed that he had not resigned his appointment. As a public servant, he was a lecturer in the university, and so that would be a ground for not satisfying the requirement of the law. There's also an election for which a supplementary poll, there's also a judgment for which a supplementary poll has been ordered in the Mokwa Federal Constituency involving Professor Jore Ganasson. Again, and that's a very critical thing because in previous electoral laws, it wasn't exactly the same. I'm talking here about the margin of lead. Margin of lead is not a fault of INEC. It's not a fault of any of the candidates. Force majeure occurred. How do you contextualize all of this so that at least we don't just heap all the blame on persons? There are forces or there are circumstances, shall we say, beyond their control.
Yes, just as Mr. Jide said, if you look at the issue of not resigning 30 days before, it's a matter of non-compliance with the requirements of the law. That does not have anything to do with INEC because it's not in INEC's place to start probing who has resigned and who has not resigned. But it takes you to intra-party politics, where you know this is a mandatory requirement of the law. You know this person is a public officer, is a lecturer. You know he is required to resign within a specific time. But why did he not resign? It goes to the issue of non-compliance with the law. It goes even to the issue of his qualification to contest that election. So if at the tribunal it is proved that this mandatory precondition has not been met, that election is bound to go down. So in that case, it is not INEC's fault. You can put it at the door of the political parties. And that is why what he said earlier now comes to play. It goes back to the politicians. I'm sure in that intra-party contest, other persons who met the requirements at that relevant time were there. So why did the nomination go to this person who had not resigned? So if you put them together, the law is there and there are mandatory requirements. So if you fail to comply with the requirements, it goes to the root of your election. And then you go to see another issue of force majeure, margin of lead. That also is a legal requirement. If they say margin of lead, in fact, you see some places where the tribunals are now saying, okay, go back and conduct election in so number of polling units. Why? Because the margin of lead and the number of PVCs collected, if you put them together, the outstanding votes are enough to determine the outcome. So most of these things, you don't always put the blame on INEC. The politicians have a lion's share of the blame in most of the cases. And if you look at this do or die affair of a thing, you look at, we talked about the legal framework. If you see the legislature-executive relations, you will find out that, look, before the eventual enactment of the Electoral Act 2022, there was this back and forth. Oh, this has not been done. In fact, when they enacted it eventually, it was like a rush game. And at the end of the day, mistakes were noticed. In fact, they almost immediately after their enactment, the legislators found out that they had shot themselves out. So it tells you that where you go back and forth, in fact, in terms of engagement of stakeholders, engagement of the public, and that's why I'm happy that he mentioned the National Institute for Legislative and Democratic Studies. This is what they have been crying about. Professor Abubakar O-Suleiman and his team. They have been crying about it. Oh, yeah, do this. Even the research he mentioned, I know something like that is in the pipeline. They've been working on it, and very soon the
there is, I just throw this in, Claire. After the 2015 elections, Plaque had a publication on election petitions, and it covered a broad range of these issues that you have indicated. So for anyone who is interested, that could be a useful resource material as a takeoff point, unless you want to start off from beyond, because you said 1999. Yeah. The only problem with 1999, 2003, and 2007, well, less of 1999, that those election figures were just being written. We have to be clear about that.
All right, let's bring in Laji Sani Yabagi, who's the IPAC national chairman, and I mean, you've listened to Jide and Dr. Oguche. Talk about, yes, the blame is, for everybody has a part to play. But most importantly, political parties and politicians. And I'm asking, how much did factionalization of parties and inter-party rivalry contribute to the type of verdict and judgments that we are seeing in post-election?
Well, party squabbles are part of life in running political parties. You can never resolve that, for as long as you exist as a political party. So those are not things that I believe have any direct impact on what we are seeing as the resolution.
You don't believe so?
No, I don't believe so because, like I said, not only in Nigeria, even other climes, you have people, within the party structures, it's about power. So you have this contest.
Yes, but they are resolved. They're usually resolved before even going into the main election. So it doesn't really affect, the outcome of
the election.
Yes.
No, well, if it affects the outcome of elections, that would be for the party that is in crisis, not for the general political space, that as it is now. I think what is important here, really, like what I've said, I'm going to repeat myself again, is about how ambiguous are the ground norm, or rather the act that is put out to administer the process and the conduct and the declaration of the results. That is where the problem lies. And one thing we must also not lose sight of is the fact that it has been said time without number that it is only in Nigeria, I don't know other places, where an elected, governor-elect or president-elect is allowed to assume office and exercise full powers of his office when he's still being questioned. When there are questions on the election known to the law, known to everybody. So we must change that. If we don't change that, there's no way you're going to have, justice at the end of the day.
But that was responsible. Again, that's a very useful point you have raised, but it was also responsible for the shrunken time delimited for the determination of election petitions and appeals.
Exactly, but why not bring it within the time frame before the swearing in?
But how do you handle that? But that's a lot.
Yeah.
I mean, that's a lot. For instance, I know, Jide, you want to weigh in here, but how do you achieve that? I give you an example. Say in a presidential election, where the entire country is a constituency, and you are alleging irregularities in multiple locations and so on and so forth. By the time you are trying to amass your evidence, the time is gone. Jide?
Yeah, I'm just saying we need to moderate our expectations. I've had the privilege and honor of observing elections across different divides. At least I've been in 3 other African countries, Ghana, Egypt, and Uganda, and I've been to US to observe elections. And I tell you for free, for instance, in Uganda, in Kenya, election dispute at the presidential level goes to constitutional court and is resolved within 2 weeks. Kingsley, you and I know that if you do that in Nigeria, no election will ever be invalidated except on grounds of maybe somebody did not resign or that. Because what will you do in 14 days? What will you do in 14 days? So we need to be careful what we are asking for. It's not a perfect system. Like you rightly pointed out, until 2010 constitutional amendment, election petition has no time limit. Then Justice Muhammadu Lawal committee sat for 16 months, and in December 2008 decided to have time limit, which is now in section 285 of the Constitution. And there is a sense in which you say 6 months is fair, may not be adequate for presidential. It may be adequate for other levels of election, governorship. For instance, governorship in Bayelsa with 8 local government with population of less than maybe 3 million. You can deal with that. But when you are dealing with a country as a constituency and you are alleging flaw in multiple states, multiple local government, multiple ward, multiple polling units, and you have to prove Because the other thing that could have helped is to shift the burden of proof on the winner or on INEC to say, come and prove that you conducted this election credibly. So it's not on the petitioner. But for you to say you want to have time limit, you have 6 months. If you say you want all election petitions to be dealt with, and let's say election petition goes directly to the Constitutional Court or the Supreme Court, and in 6 months you say it's too much, maybe you want to bring it to 3 months, people will still be shouting, we don't have enough time to prove our case. And it will be a fait accompli for anybody that wants to contest the outcome of a presidential election. But this process that we are on, if we are able to make the best of our time, and petitioners are also able to follow due process, there is pre-trial conference, there is practice direction that tells you, you want to bring witnesses, you front-load evidence. All of this front-loading of evidence, all of this adoption of witness are meant to help to fast-track the entire judicial process. But we still have people on point of law challenging and going to Supreme Court and coming back to start the novel.
Thank you. Just to in 60 seconds, how can we discourage cases that apparently lack merit, from ending up in courts?
Well, it is only in court that you find out whether a case has merit or not. So Nigerians will continue to go to court. But I like what the court started doing of late. Punitive costs. When they find out that your case is frivolous, the kind of cost they will slam such that as you are paying, you are sweating.
Are they paid?
Well, that is not for us to follow up. It's for those, because if costs are awarded, they are awarded in favor of some persons.
Are they paid?
So
are they really paid?
Why would you pay?
They will pay.
It's part of the decision of the court.
It's part of the decision, and it's enforceable.
It will be contemptible of the individual not to pay.
So that will continue, and then there's need for sensitization too. And then this has to do with CSOs. You mentioned Plaque. Young Africa is one of the front runners there. They are sensitizing, liaising with the public and political parties as well, and even Kuka Center. So at the end of the day, it is something for all.
All right.
Okay. Well, thanks a lot, gentlemen. I know the point that Engineer Yabagi raised is a very significant one, because, look, I'm sure we're all part of this. You will be discussing, the National Assembly results have been, election results have been released. This is the composition of the National Assembly. This party A has this one, party B has this one, party B. So look at the composition X, Y, Z. And now the election petition tribunals are obtaining that. You don't even know who is where, who is where. I mean, as somebody who is involved in public affairs analysis, it's worrisome.
Kingsley, we have to go.
Right.
Yes, we have to go. I'm sorry. Yeah. Let me appreciate Dr. Sam Uguchi, Consultant Coordinator, Yaga Africa Center for the Legislative Engagement. Thank you. Jide Ojo, Public Affairs Analyst. We appreciate you. And Yabagi Yusuf Sani, National Chairman, Interparty Advisory Council, IPAC. Thank you very much, sir, for joining us. All right.
That's it for us on Good Morning Nigeria today. Tomorrow is another day, same time, 7 o'clock in the morning. Look after yourselves. I'm Kingsley Osadolo.
I'm Claire Adilabu Abdul Razak. We thank you for watching. From me and the rest of the crew. Bye-bye.